One of the terms that we've heard used a lot today is the word asylum seeker. Chris just used it a number of times. Under international law, in order to be eligible for asylum, you need to either have faced actual persecution in the past or have a well-founded fear of future persecution on account of one of five grounds: race, religion, nationality, membership in a particular social group, or political opinion. General conditions of disorder don't count. States of war don't count. In order to be granted asylum, you actually have to show that you have been persecuted. And that's a very extreme concept under U.S. law in order to be eligible. And yet, in FY 2021, we had 1.659 million individuals enter the United States illegally at the southwest border, and most of them were deemed asylum seekers. The fact is, probably most of them aren't really seeking asylum, and most of them probably don't have asylum claims. Let me explain to you how that works under U.S. law. Aliens who enter the United States illegally or without proper documents are supposed to be subject to what's called expedited removal. They can be quickly removed from the United States without appearing before an immigration judge, without getting an order of removal. We just send them back home. There's an exception to the expedited removal process, however, where a migrant says either they want asylum or states the fact that they have a fear of being returned home. If that happens under U.S. law, they then get interviewed by an asylum officer at U.S. Citizenship and Immigration Services to determine whether they have a credible fear, another term that Chris used. Credible fear is a screening standard to determine whether somebody may be eligible for asylum. The asylum standard isn't actually that high. As low as a 10% chance of being persecuted back home is enough to get you asylum. This is something that is below that 10% level. Between FY 2008 and FY 2019, about 83% of all aliens who claimed credible fear were found to actually have credible fear. That means only about 17% were found not to have credible fear. At the end of the day, however, only about 17% of those individuals were actually granted asylum. Let me explain to you how that process works. If an asylum officer determines that somebody does have a credible fear, they're then placed into removal proceedings before an immigration judge. Person who was like me, and I heard a number of asylum cases from credible fear. At that hearing, there is a government attorney who can offer contrary evidence, who can challenge and cross-examine the alien. Judge makes a decision. The alien can appeal an adverse decision. The government attorney can appeal an asylum grant for that asylee. Under U.S. law, every person that enters the United States illegally is supposed to be detained from the moment that they are apprehended until they're removed or granted asylum. Again, throughout the entire expedited removal process, throughout the entire credible fear process. In 2010, however, the Obama administration, the Obama-Biden administration, decided that they were going to unilaterally and administratively change that rule. They instituted a rule that said that if you had passed credible fear, that you would be allowed into the United States on a very limited authority called parole. Nobody challenged this at the time because nobody really thought that it was a big deal. Well, it turned out to be a big deal. In 2009, before the Obama administration changed that rule, 5,325 individuals claimed credible fear. By FY 2019, that had increased 19-fold to 105,439. Aliens knew that if they claimed credible fear, they were probably going to have a pretty good shot that they would receive a positive credible fear determination and that they would be released. So it created a pull factor that brought individuals to the United States to claim asylum. Again, most of these folks did not have asylum. Many of those claims were just no good. In fact, in 32.5% of all cases in which people claimed that they had a credible fear of removal, the alien never showed up for court. This is just an example of how this system has been abused, and this is the system that we have in place right now. The Biden administration has actually offered some proposals to change this system that's going to weaken it even more. In August 2021, in the Federal Register, the Biden administration published a proposal that would take the authority for adjudicating those asylum cases away from immigration judges as a preliminary matter and give it to asylum officers. Under the law right now, if an asylee is going to apply for asylum, they have to file a government form, I-589. It's not terribly complicated. It is a little bit long. And it asks what exactly the basis of the fear is. So the immigration judge adjudicates that. The Biden administration wants to waive that asylum application rule. And you're probably wondering why they would do that. Why do you want to just have them not file an application? What they want to do is, when you go in to talk to the asylum officer, and by the way, there's no government attorney at that hearing. It's just an informal interview. It's a conversation. In fact, it's specifically non-adversarial. And asylum officers are taught how to make that non-adversarial. Don't contest anything that they say. Just listen to them, have a conversation. Biden administration wants to take that protection away. Also, there's no government attorney to appeal that decision if the asylum officer makes a wrong one. If they grant somebody asylum erroneously, that person just gets asylum. There's not going to be an appeal from that. But why exactly would the Biden administration take away the requirement that those individuals file asylum applications? They're actually pretty straightforward about that. Under U.S. law, if you don't file an asylum application within 1 year, you're not eligible for asylum. The Biden administration wants to make sure that none of those people are barred under the 1 year bar. So as soon as you sit down and talk to the asylum officer, you've made your application. The other reason is, under U.S. law, you have to wait anywhere between 180 days and 360 days after you've made your asylum application to get employment authorization. The Biden administration is explicit about the fact that they want to make sure that these folks can get their asylum, can get their employment authorization as quickly as possible. By the way, I said that immigration judges no longer have adjudication of those asylum applications, but that's only true as a preliminary matter. If the asylum officer denies that alien asylum, they can then appeal that decision to an immigration judge who's going to get a bunch of notes just like this from an asylum officer and try to put together what exactly the asylum claim is. If the immigration judge denies the application, the alien then has the opportunity to apply to the Board of Immigration Appeals. Then, if they deny, they could take it. They could file a petition for review with the circuit courts. Right now, it takes 2.45 years on average throughout the United States for an alien to even get a hearing date. Under this proposal, that is just going to be expanded because more people are going to come in expecting that they're going to have the opportunity to have a quick decision by an asylum officer. Probably many of them will, maybe many of them won't. It's just going to encourage more people. You're going to get more people coming in. There's only about 580 immigration judges, so that time is their time is going to be taken up hearing nothing but border cases. That's not the only idea that the Biden administration has, however. Remember, I said everybody's supposed to be detained. Under a leaked proposal, the Biden administration wants to set up reception centers at the southwest border. That's a place that migrants can go to. They will be given medical and medical care, dental care, psychological care. They'll have the opportunity to have their kids educated, and they can come and go as they please. Biden administration purportedly is planning on releasing many of those people just plain flat out the door, and those that they do track will be given released on alternatives to detention. There are 180,000 people in the United States currently under alternatives to detention. By the way, when we talk about asylum seekers in the United States, people who have actually filed asylum applications, right now there are 623,000 pending asylum applications before those 580 immigration judges. That's on top of 400,000 other asylum applications that are pending with asylum officers in the United States. More than 1 million people are actually applying for asylum in the United States right now. Again, reception centers, these individuals won't be detained. They're going to be non-carceral, as they say. They'll be able to come and go as they please. That's just going to encourage even more people to come illegally. Then there's a delayed proposal. We know it's out there. We just don't know what it is. Remember, I said race, religion, nationality, membership in a particular social group or political opinion, the only 5 bases for asylum. Membership in a particular social group isn't defined anywhere. Judge Alito, before he got to the Supreme Court, said a particular social group can be any group of 2 or more people whatsoever. Individuals will say that I'm a member of a particular social group of women who don't believe in living under a patriarchal structure in Central America. It can be cab drivers who don't agree with fare rates. It can be individuals who are completely neutral against the cartels. It could be individuals who have spoken against cartels. So, this is a vulnerability, but thanks to U.S. law, we've really narrowed this a whole lot. It has to be visible. It has to be recognized in society. You can't just come to court and make up a group so that you can receive asylum. We know, however, that the Biden administration is planning on watering down that standard. How do we know that? President Biden on February the 5th issued Executive Order 14,010, in which he directed DHS and the Department of Justice, the Attorney General, to review the definition of particular social group. Again, we have a standard, we have a rule, but the Biden administration wants that to be reviewed. And we know that it's not going to make that rule tighter because Attorney General Merrick Garland has already, using authority that he's granted under U.S. law, watered down that rule. Then Attorney General Sessions under the Trump administration had said in most cases, individuals who are claiming fear of harm because of common criminality, because they were mugged or they're threatened or they're being threatened because they were witnesses to a crime, those individuals aren't generally eligible for asylum. Attorney General Sessions also said domestic violence is a horrible thing, but it doesn't really fit any of those 5 factors for asylum relief. Attorney General Garland has reversed that decision as well. So when you take all of this as a whole, when you take 1.659 million people entering illegally, when you take this proposal to give asylum officers the ability to adjudicate asylum, the erection of reception centers, and then a watering down of the asylum standard, what you're going to do is you will have 1 million people show up illegally every year, and you're not going to have an immigration problem. You're going to have an asylum processing system that will usher 1 million people plus into the United States every year. So literally, it will take what is currently against the law and make it a process to enter the United States illegally. What should be expedited will become the exception that swallows the rule.